is a registered US IP attorney, and he is an off counsel with Mlegal. And I am Mohit Suri, the managing partner at Mlegal. We're going to be talking about IP. I'm repeating this because a lot of my friends just joined. So I just wanted to give them a heads up and say that what we are going to be talking about. IP is Amit's forte, so I would let him do the majority of the talking today, and would just like give him a nudge here and there. So Amit, what is an IP? Why do we need an IP? Can you please?
Okay. Yeah, Mohit, before we get into the nitty-gritty of things, but thank you for having me over, and hello everyone. Hopefully this conversation helps you at least get the ball rolling on your knowledge of IP, intellectual property. So now, Mohit, coming back to your question, what is intellectual property? So it is literally, in the broad sense, the rights given by a government for your intellect, things that you come up with, ideas that you come up with, inventions that you come up with. And the reason why I distinguish or separate these out is because under the broad umbrella of intellectual property, you have different IP rights, patents, copyrights, trademarks, trade secrets, etc. So we'll get into those details. But the short answer to your question, what is IP? It's the right given by a particular government to monetize as well as take advantage of your own intellectual property.
Okay. So what's the difference between patents, copyrights, and trademarks, Amit? And probably trade secrets as well.
And okay, so this is obviously it goes into a lot of details, but let me start off with the simpler things. One of the lesser known intellectual property right are trade secrets, and the trade secrets is generally confidential information that companies want to keep within their company itself, including employees, and they don't want to disclose that their information to other competitors. So trade secrets are generally those. Obviously, as you can imagine, these are kept confidential, so automatically you're not granted any rights. So as far as legal is concerned, the employees often sign non-disclosure agreements not to disclose the information to competitors or other people. But you are not granted any exclusive rights because there is no other body involved. The next thing would be copyrights. Copyrights typically are original artistic works of authorship, and those exist the moment you come up with an artistic work of authorship. To go in slightly into non-legal lingo, imagine a company invents a car, right? It wants to get an intellectual property right on that car. That would fall under the patents, which we'll talk about in a second. Then they come up with a name for the car that will fall under the trademark regime, which we'll also talk about in a second. But then they, hypothetically speaking, hire an ad agency, or they might come up with an ad to market the car itself. Now that ad is not directly related to the product itself, but it is considered an artistic work of authorship. So in that case, the ad itself would get a copyright, if that makes sense. The main thing about copyright is you don't really need to register a copyright. You don't need to file an application for a copyright. The moment a work of authorship is created, you get the copyright itself. The copyright starts existing the moment it's created. However, having said that, if you say you write a poem, you come up with an ad and somebody else copies it, and then if you want to sue that other entity, in that particular case, you will have to register your copyright in order to sue them. So those are two subtle nuances with registering versus existence of copyrights. Any questions so far before I delve into trademarks?
I don't have any questions. I don't know if the listeners understand all this.
Okay. I mean, I can always
Probably
speak in
let's
a
move
less.
trademarks. Let's move on to the trademarks, and so that we can actually go with the flow and see the advantages of each and differentiate between them. Because you picked up
Okay.
a good example, that of a car. So I think
Mhm.
I think if I were to understand with the car, I can explain the patents, I can explain the copyrights, and I can also explain the trademarks. So it's a good example that you picked up.
Okay. I mean, I figured it'll be easier for most people to
Yeah.
understand instead of talking about a pharmaceutical composition, for example.
Of course.
So, right. So, coming back to the trademark application, as I was mentioning, say Mohit comes up with an electric car or a car, and then he can get a patent on, assuming it meets all the necessary requirements, he can get a patent on the car itself. But then the name of the car, if he decides to call it specifically Mohit's car, that is not really an invention, but it's how you distinguish your product. And I'll also include the generic description or service, and you distinguish that from that of other businesses or competitors. So that's typically a trademark. And for that, you do have to register it with the appropriate authority. In the US, it's typically it's the U.S. Patent and Trademark Office, the USPTO, and in India, it's the Indian Trademark Office. And so, as I was saying, if Mohit wants to register a car and call it Mohit's car, he'll have to file a patent. He'll have to file a trademark application with the Indian Trademark Office. They will do a search, see if there are any other Mohit's cars around. If there aren't, then Mohit gets that trademark, and then Mohit can market and use Mohit's car as a trademark exclusively. So others who follow him will be prevented from using that particular trademark.
Perfect.
So far, so good.
So far, so good. So let me just bombard you with another question because it's Mohit's car. So Mohit is going to be bombarding you with questions. Do I really need you, you as an IP attorney, if I needed to file a trademark? Copyright, you say, is already mine. Do I need you to file a trademark or probably even a patent or any other IP, or can I just do it on myself?
That's a very good question. So because you also hit copyright in there, as I mentioned before, copyrights automatically exist the moment you create them.
Yes.
But I also did add the exception to that is that you do have to, in case somebody infringes on your copyright, you will eventually sue them, and that you have to kind of have to do it through an attorney. So yes, copyrights exist without an attorney's help, but to sue somebody, you will need an attorney's help. When it comes to trademarks, same thing. The procedural application part might appear simple, but as I mentioned in my a minute ago, that the trademark offices, depending on the jurisdiction, will do a search for similar sounding or similar trademark applications. So typically when trademark attorneys file applications, they will preemptively do these searches. I do that often, where I'll preemptively do a search before the office itself does it, and make sure that you as an applicant is on strong legal ground to get your trademark. So yes, that is absolutely, as I said, it is possible, but it is highly and strongly recommended that you do through it, file your application through an attorney. Now, when it comes to patents, it becomes even more crucial because trademark is, as I said, it's just the way you distinguish your product or services from others. But a patent has tons of requirements. You have to write a thorough patent application. You have to meet multiple procedural checkboxes, for lack of a better term. And all of those, although they might sound very procedural, there are subtle nuances and complicated nuances in terms of interpretation of how these things are taken forward. So I personally don't know of a single person who has filed a patent application on their own. And even if people have done that in the past or are considering doing it, eventually, once they get to that initial office action stage, which we'll discuss that in a second as well, then they scramble around to hire an attorney because they don't know what to do next.
Okay.
So it's always recommended. Obviously, we're tooting our own horn, but it's always recommended to get an attorney to do all your applications.
Perfect. Perfect. So how much typically would be the cost? Like since since Mohit is inventing the car and he's he's registering it, how much would it cost me, to register probably a trademark or a patent with, say, my own steering system, probably some new steering that I've invented, or some kind of a new car source that I've invented? How much would it typically cost me? And are there different categories under which I have to register my trademark and my patent, or I just have to go through one category itself?
That's actually also a very loaded question. There are multiple. I mean, without getting into too many details, I'll separate out the trademarks and the patent applications. I'll separate them. Trademarks are typically cheaper because there's less review. There's less effort involved on the trademark office's part to do a search. It's typically cheaper. The prices or the fees itself vary by jurisdiction. So depending on whether you're filing it in India or whether you're filing it in the US, obviously the fees are different. And I don't want to give you definite numbers because obviously this will be online and the fees often change. The trademark offices, patent offices have the rights to change the fees as needed. So if I give you a number, it might be relevant today, it may not be relevant a year from now. So, but having said that, regarding the exceptions, now let's talk about patents. As I mentioned, the US Patent and Trademark Office has its own fees. However, both the USPTO as well as the Indian Patent Office have something called small entity, which allows you to get a 50% reduced application filing fee. And you have to hit certain criteria to be eligible as a small entity. One of the newest things as far as the Indian Patent Office is concerned is they just broaden the definition of what counts as a small entity. So a lot of educational institutions are now eligible for that category. And under those things, some of these fees are reduced by up to even 80%. So that's a big deal, especially for small businesses, entrepreneurs. As long as they hit certain check marks, they can file the applications for cheap, relatively speaking. Now, as for answering your other question, do you just file a general application and is that it? The answer to that is yes and no. As far as the patent application is concerned, you just have to make a selection on what category of patent application are you filing. Is it for the utility of the invention, as you mentioned the steering wheel? Are you using that as a utility, or are you filing a patent application on the design of the steering wheel? Now, the design patents are a separate category, and then there's cheaper as well. It's literally said in the words. It's the design of your invention. Whereas the utility, as I said, there are multiple requirements, there's specification, claims, which define the scope of your patent application. And that gets more expensive because there's more work associated with a utility patent application and issuing that.
Okay. So
Yeah.
typically, what would be the attorney fees for filing a patent in the US or in India?
So I can speak to Indian patent attorneys. Obviously, they might have their own fee structure, but for most firms that I know of, and it varies from firm to firm. Most big law firms in the US will have a billable hour, and that can, depending on the expertise and depending expertise of the lawyer, and depending on how complicated the patent application is, it can vary anywhere between I want to say about $400 to $1,500. So there's no defined number, a specific number, and that's only for filing. Once the application is filed. So this kind of ties back to your earlier question as to should people use attorneys. More often than not, the Patent and Trademark Office, both India as well as the US, will come back, they will do a search and will come back and say that, oh, this is already information out there, and any public information, there are rules to this, but any public information cannot be patented. So they'll do a search and they'll say, oh, this is already out there, so you don't deserve a patent, so we're rejecting your application. And that process is called an office action. So that's where attorneys step in. They'll review the application itself, they'll review the office actions, and then make a case as to why their client should get it should be issued the patent. And that, again, depends on coming back to your fees question, that depends on the number of hours involved, how complicated the office action is, etc.
Yeah, I'll just let you relax for 2 minutes and I'll tell you how the procedure here works. And things are very similar. Of course, internationally now, because IPRs are more international than any other law, because a product in India, when Mohit starts his car business in India, he is obviously going to be selling in the US as well, and obviously in China or probably other countries as well. So he needs his IPR to be protected everywhere. So this is one of the most internationally uniform laws. India actually never used to have a computerized IPR till even say 2014. So that's like now. Right.
Yeah, very recent.
That's when they started going online and having your online applications and converting all the applications received to digital format. So what happened at that time was whatever applications we would have, they would invariably be missing. You know, like you would really be scratching your head when they said, like, we can't locate it. And then there are a lot of issues. But now things are very smooth. But still, from my experience, what I've seen is whether you have a similar trademark or not, whether it's totally different or whatever, you'll always get a challenge. So that's why I would actually suggest people that they should actually hire a lawyer at the right time, because you have to pay them. And then at a later stage, after you've done the filing, what happens is lawyers, including me, we have a habit of finding 100 faults with what you've done, even if we would have
in the
done
past.
Yeah, of course.
Like exactly.
Is the reason for this mess, you know?
Right.
In this mess, like this is the way we work, and this is the way we've been brought up, actually, and this is the way we've been trained. So anything which somebody else has done is the worst thing that can ever happen to you. So
that's true. And on that point, I do think, as far as the clients are concerned, it is more economical if you tend to hire a lawyer and stick to the same lawyer right from step 1 to step A to step Z. And it's more economical. Of course, that doesn't always work
The number
out.
of
It's
hours also go down. Actually, like this is,
yeah,
if I have to read somebody else's application, it takes much more time for me than what it takes me to read my own application. And like
right,
most of the lawyers, including you and me, are tech savvy now. So what
right,
happens? Most of our editing and most of our drafting is actually done by ourselves while
exactly.
we're just
Yeah.
looking at it, because it's easier for me to actually type or dictate the application
Hmm.
rather than I read somebody else's application and then start making the corrections, because it takes me more
Exactly.
time doing that. It takes me more
Yeah.
time. So
If I can add one more thing to that, especially when it comes to patent applications, uh, a general process that when lawyers file a patent application, there is, besides the typing and the drafting of the application, even before that step, which I would, for lack of a better term, let's call it step one, there's step zero, where you sit and talk to the clients, where you sit and interview them in a way, ask them what their invention is, and try to understand the application itself. And that is a very crucial step, because especially when it comes to patents, there are something called a set of claims, and that how broad those claims are or how narrow, that will define on how strong your patent. And to draft a good set of claims, it is important to understand the client's thought process itself, and that's not going to happen by just reviewing somebody else's work.
yeah, of course, like I agree with you. Okay, I have one typical question for you. Supposedly,
Hmm.
Mohit's car was registered in India. Okay, I got
Hmm.
my patent for my steering. I also got
Hmm.
my trademark registered. Do I have
Hmm.
to go through the whole process in the United States, or is there any international convention through which I can just approach you and say, okay, boss, I'm already registered in India. Now, does the Geneva Convention or the French Convention or the Paris norms or anything apply to me? Can you just get me through the shortcut?
Okay, so again, a very loaded question. Unfortunately, patent rights, as I mentioned, are government issue, and obviously each country has their own government. So those IPRs, intellectual property rights, are limited to the country where or the jurisdiction where you filed it. So if you file a get an Indian patent, that's only valid in India, not necessarily in the US. But then you would automatically think, but why would that sounds very expensive? But the caveat there is that once you file a patent application, once you are actually you have filed a patent application and it's published, then that can be used to reject others' patent applications in other jurisdictions. So in a way, your rights extend indirectly to other jurisdictions. But it so others can get you the same patent, but you don't have the same patent in other countries. So you will have to file individually in India as well as the US or other countries. Now, as I said, it's a loaded question. In addition, there is something called the World Intellectual Property Organization, and they have a filing process called it's literally called the international application. The international application doesn't give you rights, but it gives you a date based on which you can file multiple patent applications in different countries. And that's typically 30 months from the date of filing in the World Intellectual Property Organization, or WIPO. So that's what the I mean. I know it's a very vague answer, because it is a very it's not my vague answer. The question I mean, the answer itself is vague.
Okay. So if Mohit's car is registered in India, what do I do with
Mhm.
the trademark? Would you take my trademark to be valid in US, or would you just say that, okay, boss, you've done it in India, now you start from scratch and you start filing in US?
No, actually, that's a very good question. If you have a Mohit car in the US, I mean the trademark in India, right? And I come assuming I also want to file a trademark application called Mohit's car. right? It's going to be rejected outright because you already have it, right? So, but now if you want to market it in the US, you can use that as as number one, as an issued trademark in India, and make a case that I already have this. That's why you should get me the trademark in the US as well. So it's an indirect answer, but it almost
If
gives
somebody
you
else
broader
make it
rights.
in US, if I file for a trademark in India, I just got it probably yesterday, and in the meantime, you realize that Mohit's getting a Mohit's car registered in India. Can you squat on my trademark in the US?
Uh, as long as you filed it, and again, ties back to why you use attorneys, right? As long as you met all the requirements, it automatically shows up in all the databases. And if I just try to preemptively bypass you and file this thing, depending on the filing date, if I file it before you, my filing date is earlier, obviously, and then you might not be able to get your trademark, and vice versa.
Okay.
So it's all about the filing date and also making sure you meet all the requirements for filing these applications.
That's very interesting. Actually, okay. So here we have, even if you file in a class where you don't have similar trademarks, they always have objections to it. They always have objections to it. Same goes with the patents. So I would actually, if any of our listeners or any of our viewers ask me that, do they really need a lawyer for an IPR? I would say yes. I would actually give an outright answer. You've been very kind and very polite in actually giving them opinions. I would just be a bit more rude and I would say, okay,
right.
Though even if you get sick, you can still have Panadol, but you might have COVID-19, for which having Panadol, you'll have more complications.
right. So my approach is in this particular regard. Yeah, you can get Panadol or you can get COVID-19, but if I'm the one who is treating that COVID-19, in that person's mind, like, oh, he's just trying to get more business. So that's why my approach is, look, I recommend you get a lawyer, but I won't force you to go with me. But you can choose whoever, and of course that gives the client the choice about who to go with, what to do. And then the next time, as we talked about, there are bound to be complications. There's bound to be a time when they need lawyer.
They will need a lawyer.
And then they'll be like, okay, this guy didn't force me, so let me go with him.
Yeah,
that's my approach.
So Amit, like we are almost out of time, and I think most of our viewers have been here and they've been very kind and they've been listening to our yak with each other.
Right.
Both them legal lawyers shooting each other and just clearing their own doubts. But see, what happened, both India and US, in my experience, are very litigious legislations. The jurisdictions are very, very, very litigious, and they are lawyers' heaven, basically. India, because sheer number of cases, sheer number of backlogs, sheer number of opportunities. US, because you have a different law in every state, so many cases, so many different jurisdictions, so many different laws under which you can be sued. In India, I was actually analyzing, there are 2,600 ways in which a businessman can end up in prison in India. 2,600 ways.
Oh man.
So
all the more reason to hire a lawyer at the very start.
If you don't have a lawyer, you can actually ask Mlegal for a list, and I can give you 2,600 reasons why you should hire a lawyer and not go direct. And now I would thank you for being with me, and welcome to the Mlegal.
Thank you for having me. But I just on your last point, I feel like I should just point out, as far as intellectual property rights are concerned, they're not in the US. They're not state-based. It's federal law. So it's only it's only through the patents and trademarks are through the USPTO, and copyright is through the Copyright Office. So just a minor correction there, but sorry.
Sure.
Yeah.
No worries. So I would like to thank everybody and you for joining us. And it's been a great conversation. I think a lot of your concepts and a lot of my concepts have been cleared. And we look forward to a lot of applications because I think a lot of Indian businesses are looking at the US and a lot of US businesses are looking at India. And we've had a lot of firms in the US approaching us because they bought patents which are in dispute. And they look at our services in those cases. So we can actually help everyone. And we try our best to help everyone rather. And try to give our best opinions and best efforts towards solving their rights, not just on the IP field. Mlegal is a full service law firm. As I told you, specialize in mergers and acquisitions, for which you actually need to understand IP as well, because in all business transactions, IP is a part of it, taxation is a part of it, contracts are a part of it. And of course, if you don't understand them, you can't be a transaction lawyer, because
of course,
that's the way it goes. So I've been in the field for over 20 years. So I think I'm more or less sorted out as far as our legal practice is concerned, and I'm able to help corporates. We've worked with all top law firms like Latham Watkins, Greenberg Torek, Withers, Woodwide, and with consulting firms like Deloitte, E&Y. So like, I think if any of our viewers have any issues, they should feel free to ask for our opinion and seek our counsel. And I think it would actually save you a lot of time and money rather than trying it yourself and then coming to us after messing up your matter or your case or your IP application. Thank you, Amit. Thanks, everyone. If you have a question.
Thank you, Mohit. Thank you, everyone. Please feel free to get in touch with us if you have any questions.
Yeah. Thank you, guys. I'll just
all right. Thank you
now. And I thank you all for coming on once again. Thank you very much.
Thank you. Bye.